Hi, good afternoon, everyone. Um, Today we have a very interesting topic. We're going to address H-1B visas. It is that time of the year again. I'm just going to give a few seconds for people to join. And if you could please let us know if you're hearing us okay and seeing us okay, that would be great. Okay, so I guess our video and audio is fine. We are now live on YouTube as well. It is a pleasure to invite Chris Costa to speak on the H-1B topic with me. Hello, Chris. How are you?
Hi, I'm doing great. How's everyone feeling today? I know I won't get a response. But...
They will. They're all excited about this, I'm sure. So I'll start sharing our presentation and I'll go over it. I'll show you guys the agenda and I'll tell you a little bit more about our speaker, Chris, and about myself as well. One second. Okay, so H-1B visa, how can I start my application? Well, let me talk to you a little bit about Drummond Advisors. We're a multidisciplinary firm and we specialize in cross-border transactions. We have legal, accounting, tax, and advisory services. We have a team of accountants and lawyers with experience and certifications that operate in the US and Brazil. We have offices in Boston, New York, Miami, Orlando, São Paulo, and Belo Horizonte. Soon in Rio de Janeiro, I'm sure we have a big team there. More than 10 years of experience, more than 3,000 clients served, and a team with more than 170 employees. Well, this is me. I'm a senior associate here with Drummond. I've been here for more than 3 years. It's a pleasure to be here with you. And here's Chris Costa. He is our senior associate as well. We work together and he's licensed to practice law in the United States in 2 states, New York and New Jersey. He holds a bachelor's degree in political science from Boston College and a JD from the City University of New York School of Law. He has more than 7 years of experience in immigration law, so he's also in love with immigration like I am. And he has substantial experience with H-1B visas, which comes in very handy for this webinar. He has dealt with various areas and various sizes firms, and he has done in-house counseling specifically for H-1B cases in multinational companies from technology background. Do you have anything to add, Chris, on your end?
In terms of H-1Bs, I'm a big fan and just looking forward to the webinar. I guess I'll talk about my background later in terms of any questions if they were to come up.
Well, thank you so much. Chris and I will be talking to you guys a little bit on a summary of the H-1B visa petition in general, the H-1B cap and cap exemption petitions, or cap exempt petitions, I apologize, premium processing fee, which is optional. We'll talk about it in deeper details later. We will be addressing the H-1B visa process per se. It is a fairly new process, but it's already well established. We had some doubts if other criteria would come up regarding prevailing wage determinations and things like that, but we already know that this is settled. We will show you a timeline for the H-1B process, meaning all the steps and timeframes to complete this process. We will talk about H-1B visa filing fees, cap gap for F1 students, and finally, frequently asked questions, meaning we'll open up for you guys to interact with us, pose your questions. There is a Q&A box here where you can also submit your questions, and we will be happy to address them. If by any chance we don't have time to address your question, you will get our email address, and we're very happy to answer your questions later on. Okay, so let's get to the gist of the H-1B visa. So Chris, can you tell us a little bit of the H-1B visa, what it is?
Sure. So I guess stepping back, the previous slide, I'll first go over the first 2 points.
I apologize, it's not going back, but I'll figure it out. 1 second.
Oh. Okay, so I'll just basically start by giving you the broad overview that an H-1B visa is for professionals. That's like the fundamental requirement. You have to be a professional, you have to have at least a bachelor's degree, and the job has to at least require a bachelor's degree in your chosen profession. And obviously, the company that's sponsoring you has to do business in that area. So to start, non-immigrant visa, dual intent. This is a big benefit of H-1B visas. Most non-immigrant visas, which are temporary visas, require foreign nationals to intend to remain in the United States only temporarily, initially for the validity period of the visa that they're issued. The H-1B visa, however, permits foreign nationals to have the intention to remain in the United States permanently, as opposed to just temporarily beyond the validity of their initial visa stamp period. And this means that H-1B visa applicants won't be questioned about their ties to their home country, like many other non-immigrant visa applicants. And being a dual intent visa, applying for permanent residence won't affect the possibility of visa renewal, and it also won't affect timing for international travel, which I guess that's a little bit of a bigger topic. But in sum, being a dual intent visa is a big benefit. Sponsorship required. H-1B visas require sponsorship by a US employer that does business in the area of the foreign national's profession. That's a basic requirement. So for any individuals listening, if you're interested in an H-1B visa and you don't have a potential sponsor in mind, now is the time to start looking for one. And we'll get into the timeline a little later. Would you like me to continue?
If you want, I can take it from here. So the next requirement is to be a skilled professional, and also that the position that you're willing to apply for is a specialty occupation, meaning you have to have a graduation, you need a diploma, right? You need to be in a specialty occupation, meaning you need specialized knowledge to perform in that position. So we usually have to validate your diploma if you graduated in a foreign country, right? If you graduated in the US, you have a little bit of an advantage that we will discuss later on, because people with master's degree here in the US get more chances of being picked, right? This is the area that caused more turmoil here in the past few years with H-1B cases, especially during the Trump administration, because clearly USCIS changed a little bit of how they saw the meaning of skilled worker and a specialty occupation. And this was not updated in the regulations, but we recently have seen that this is being fixed, right? We had a lot of litigation on this matter, and things are back to how the rule establishes this concept. The visa is initially granted for a period of up to 3 years. We always say up to because there is a little bit of discretion on the officer side, but usually they're granted for 3 years, and they're extended here for a maximum of 6 years, with few exceptions. If you continue on with the same employer and you file for a perm and other very specific cases. It is very relevant to mention that derivative spouses may not be eligible to work in the United States. There are exceptions, but in general, this is the rule. So Chris, can we talk a little bit now about the H-1B cap and the cap exempt petitions, meaning you can't just file for H-1Bs all year long. You can't just file for H-1Bs as you please, right? There's a limitation. So can you tell us a little bit about this?
Sure. So there is a numerical limit to the number of H-1B visas available. At the time that H-1Bs were promulgated, it might have been enough, but in recent years, this total of 85,000 doesn't nearly meet the need. In general, in the US, there are about 3 times as many applications per year. So this results in the establishment of a lottery. So in terms of the 85,000 H-1B visas available, 65,000 are marked for specialty occupation professionals with at least a bachelor's degree, and $20,000 visas are specifically available to people with advanced degrees from a US institution. So that includes like US masters and above, PhDs as well. So it is a benefit to have a US master's degree or above, because your chances are slightly higher in terms of selection.
Right, because they could be either on the 65,000 cap or their own cap, right? And it's interesting that you mentioned the lottery is actually not the rule, right? But we see it so often, and every year it is done through lottery that people assume that this is how it should be. But it's just that we have so many applicants every year, right, Chris, that this is how it goes. They have to do the lottery.
Yeah, it's a procedural necessity nowadays until the limit is increased, hopefully, possibly in the future. So one last thing, there are 3 categories of occupations that are exempt from the cap of 85,000 visas. And those are jobs for an institution of higher education, jobs for nonprofit organizations that are associated with an institution of higher education, which could be NGOs, clinics, hospitals, et cetera, that might have collaboration or a program, a clinic, in terms of hospitals. Those are just examples. And the last category would be a job at a governmental research center. So people, petitioners that meet these criteria can petition for H-1B visas at the same time during the same process, but be exempt from the cap, which is a huge benefit.
Meaning they don't have to go through this process, and they're not subject to this limitation, right? Of 65,000 H-1B visas for people with bachelor's degree, or the 20,000 for people that graduate in the US.
Mm-hmm.
Right, so now premium processing fee. This is a category that is interesting on the H-1B cases, because in certain years we've seen that they did not make it available, right, Chris? Certain times they suspend the ability to file for a premium processing application in H-1B cases. Can you tell us a little bit about how premium processing works for H-1B cases?
Sure. So H-1Bs are submitted for a start date on the next fiscal year, and USCIS's fiscal year starts on October 1st. So petitions can be adjudicated in April, let's say, of every calendar year. They can be adjudicated within 15 calendar days if premium processing is implemented, but the start date would still remain October 1st. It's a big benefit to actually have adjudication happen earlier, because oftentimes adjudication can happen near or even after October 1st. And USCIS sometimes suspends premium processing just due to labor just not being able to handle the volume of petitions. It definitely happened during COVID, and it's a possibility. Like, we can't guarantee that it won't happen during this H-1B season, but premium processing is available for an additional fee of $2,500, and it provides adjudication in 15 calendar days.
Perfect. So even though you might not be able to start prior to October 1st, it is a good benefit, especially for those that are here on an OPT, right? They have certain benefits as well, and they have a very specific cap gap provision that we will discuss later on. Anything else on premium processing?
That's pretty much it. That's all you need to know. Pay a little money, get a decision faster. With immigration, it's usually worthwhile to pay a little more and, have more peace of mind.
Awesome.
And keep in mind that you could also the petitioner could also receive a request for additional evidence, which eats into the time a little
right
bit.
That's something we always have to consider, right? Yes. And that would give us a speedy process, because then you have, again, 15 days to get a response after you submit the response for the RFE or to the RFE. That's a very good point. Now let's get to what the H-1B process really looks like now. So it is recent, but not too new, right? We already had in 2021 the new way to do H-1B cases, and it will remain the same. We had some turmoil and some lawsuits and new plans, right, on doing this over wages, but finally we got this issue resolved, and we're back to where we stand now. What can you tell us about this process, Chris? How can we advise all the listeners on what the H-1B process now looks like?
Well, in terms of process, the most important date to keep in mind is April 1st for H-1Bs. And employers should also keep in mind that there's prep time involved. So soon after New Year's, immigration attorneys are already, in H-1B mode. So, that's the most important thing to keep in mind, that, there is prep time involved. And like we're detailing here, the process has slightly changed. Since 2020, employers have been required to submit an electronic registration rather than the entire petition, and it's actually a lot more practical. The registration just provides basic information about the company and the requested worker, and then only after selection in the lottery and a selection notice is received does the petitioner submit a copy of the entire petition. This doesn't mean that there doesn't have to be a little due diligence before, but it means that the process is definitely less burdensome. So,
yes. And I apologize. Continue.
No, keep going.
Yes, and I particularly could say that this made it a lot better and safer, right? I see that it's easier for USCIS to foresee any fraudulent cases, and we have a lot more chances to actually get all the 65,000 H-1Bs and the 20,000 H-1Bs used every fiscal year with this new system. At least that's my personal opinion. And we saw a reduction of the overall costs for both petitioners and USCIS because before the selection would occur with the complete packet. So you would have to pay the attorney, you would have to prepare, draft the whole case, send it to USCIS, pay for FedEx, do all these processes, but then you wouldn't be picked. So it was a really big thing for USCIS to even have that space for all these petitions, then select them, then send them all back to the people that were not selected. So now we have a more effective process, even cost-wise. This process prevents fraud and multiple applications because this all goes to a system, an online system, so they can cross-reference this information. So if the same applicant is showing up several times, you can easily see that and just remove them from the lottery process. Preference and priority to highly skilled workers and highly paid workers. This was something that was about to come to play, but it's no longer a criteria to select people. But obviously it plays an important role when we're actually submitting the file and we're showing USCIS why this person is important to the US, to the company, and we need them rather than a US worker. All right, Chris. So we gave a broader view of how the H-1B process is looking like now since 2020. And if I want to apply, how do I do it? What's the timeline? What are the steps?
Okay, so this is our general guidance for preparing for an H-1B application in a timely fashion. So we're already in January, but it would be advisable that in early December, petitioners would start identifying their H-1B needs for the next year, discuss strategy with their immigration attorney, and finalize the list of documentation needed from the petitioner side, at least. In early January, gather and request required transcripts and experience letters for prospective beneficiaries, if necessary, to begin obtaining foreign credential evaluations. Again, if necessary, in early February, begin gathering supporting evidence for employer pre-registration. March to March 20th, submit the H-1B registration along with a $10 registration fee. And like we mentioned, the process is a lot simpler. So nothing really prevents an employer from submitting H-1B registrations for multiple employees, just to hedge their bets. And individuals can also be registered by multiple companies. There's nothing prohibited about that. And that's, I guess, good strategy if possible. March 31st, very likely, the lottery results for the first round of selections would be announced. There may be a second round lottery depending on demand and non-submission of applications by selected employers. There might even be a third lottery. It really depends.
Right, because they want to use up all that's available, right? So if for some reason a person was selected and didn't apply, or they didn't meet the criteria, they kind of back into play, right? And those that were already registered by March 1st or March 20th, or this first period, can get a chance to be selected later on. Okay, thank you, Chris. So the timeline continues. And so after we learn about selections, selections are issued online. So we get a selection notice through USCIS's online system. So that gives us from April 1st up to June 15th, or sometimes June 30th, to submit the packet per se, meaning the labor certification, the credentials for the beneficiary, documentation from the company, support letter, forms, and all that involves an H-1B case. So here we're listing some. So the prevailing wage has to be determined. We have to have a very detailed job description to justify it's really a specialized knowledge type of job position. And we need to gather supporting evidence for all of this, including company documentation, including documentation on the industry and other positions that are similar to this, the labor certification and form support letter and any other supporting documentation. From April 15th through June 25th, the petition will be mailed to USCIS and it must be delivered before June 30th. In this case would be 2022, I apologize. Usually the selection notice will give us the due date, but usually that's what's been happening. June 30th has been the limit. Then from July through September, hopefully USCIS will adjudicate all petitions. As Chris mentioned, there are RFEs that might be issued. So this is very relevant. So if premium processing is available, that's why we usually encourage our clients to apply for this with premium processing. Finally, October 1st, as Chris also mentioned, is the beginning of the fiscal year of 2023 in our case for USCIS. So that's when whoever was selected and approved on the H-1B case will be able to start their new job position with the sponsoring company. So it is possible to prepare your petition and if selected, have it ready to be filed. That's what we were mentioning before. A lot of our clients, they start as soon as December, gathering documentation, understanding the level of detail that it involves to have a good job description. So we kind of work on this file, and if they're selected, we already have it ready. So we're more prone to submitting it by April 15th instead of just submitting it by June 20th, which also gives us more leeway in case we have any RFEs or any other demands. Important, a new lottery takes place before September in case H-1B caps for the fiscal year are still available. That's what we mentioned very quickly. If all this happens and not all the H-1B case, caps that were made available are fully used, USCIS will put them back into the lottery process, and people will have a second or even a third chance, right, Chris?
Yeah.
Do you want to say anything about this final side of the timeline or these notices?
Well, people in the United States can apply for beneficiaries in the United States can have an application for a change of status rather than for consular processing. That's a decision that I guess is personal to the individual and to the company.
Right. You are right. Here we're mentioning to go to a U.S. consulate or embassy abroad. However, if it's your case and you're here in the United States, we can always do a change of status for your petition.
Mhm.
So filing fees, what do you have to say about this, Chris? Is it scary? How is it looking?
Well, I guess it's looking a lot better now because the registration fee is only $10, does not prevent multiple registrations. And if you're not selected, you don't actually have to pay the filing fees, which was the case before. So if selected, which would be great news, the base filing fee is $460. There's an anti-fraud fee of $500 for new H-1B applications only, and those would be the ones in the lottery, not extensions. There's an additional fee of $750 for employers with less than 25 employees and $1,500 for employers with more than 25 employees. There's this public law fee of $4,000, which is generally not applicable to most employers. So I guess, we won't really get into like specifics. And then the premium processing fee of $2,500, which is optional and, like we mentioned, might be available or might not be available.
So this is very interesting. If you are here in the United States, you are on an F1 status and you have the chance of getting an OPT, or you are entering an OPT period for your STEM OPT, which is even greater. What's the benefit, Chris? What happens to these students?
Okay, so F1 students have to be careful when it comes to H-1B because if they're already on OPT, then the timing just becomes very important. So cap gap extension, which refers to like extension of the period between their OPT validity and the October 1st start date, is available to students either on approved OPT or STEM OPT or in their 60-day grace period, which is right after that period, and have a pending or approved change of status for an October 1st cap subject H-1B petition, which was filed prior to the expiration of their OPT or STEM or 60-day grace period. So they still have to be in that period come end of March when filing will actually take place.
Right, because that's very important, right, Chris? When we're doing just the pre-registration step, none of that gives them any status, right?
Yes, yeah, exactly. So definitely keep that in mind because otherwise it would require the individual to go abroad and then come back with a visa to start H-1B employment.
So these folks are one of the folks that we would encourage starting early, right? Getting their dossier ready, having it early on, because if they're selected, they're better off if they file it by April than waiting until June to actually submit their case and be locked in the change of status.
Yeah, exactly. And their employers should be aware that timing is a particular consideration for people on OPT. So here we mentioned that there's eligibility for one of two cap gap extension benefits. If the employer filed an H-1B change of status petition and it's received by USCIS prior to the OPT expiration date, then the beneficiary qualifies for an extension of OPT employment authorization, which is pretty big. That means that they can keep working until October 1st or when they assume the H-1B visa.
This is the greatest benefit they could get, and this is very exclusive to people under this specific status, right?
Yes, exactly. If the employer filed the H-1B change of status petition and it's received by USCIS after OPT expires, but during the 60-day grace period, then F1 status is extended, but employment authorization is not. So that's a little unfortunate, but at least F1 status is extended.
Right, that's what you were saying. Like you have to be very mindful of exactly where you're at with your OPT status or your F1 status, because it makes a huge difference into what are the benefits you're getting while you're doing your change of status to the H-1B.
Mm-hmm. Yeah, exactly.
Okay, do you want me to continue?
Yes, yeah.
Okay.
You can address any
So
questions.
then you must confirm with your employer if the H-1B will be filed as a change of status or consular processing. That's something we were mentioning. You can do either or, depending on your case if you're in the US. So I would always advise you to consult with a good immigration attorney who could check all these details, right, and see exactly where you're at and advise you wisely and appropriately as to what's your best shot doing a change of status here in the US and maybe getting all these benefits, or going to your home country and applying through a US consulate or embassy in your home country, right, abroad. You may be eligible for one of two cap extension benefits. So if your employer filed your H-1B change of status petition and it is received by USCIS prior to your post-completion OPT expiration date, you will qualify for an extension of your OPT employment authorization, meaning you will not have to get out of your payroll, right? You will continue on your same position and you will continue to earn your salary and so forth. However, if the employer filed your H-1B case here in the US with a change of status and USCIS receives your petition after your OPT expires, you only have the 60-day grace period. So only your F1 status and the permission to remain in the US are extended, but you cannot continue to work. Well, we got over a lot of topics related to the H-1B. Now let's see what everyone has been asking us so far. So here we have an anonymous attendee who asks, having an H-1B, do I need to do change of status to an EB-2 for applying to the green card, or is it directly with H-1B that I can apply to a green card? So here, what I think the person is asking is, do I need to maintain my H-1B status while I'm applying to my green card, right? And the general answer would be yes, because during the whole period of your perm that is going to take place with the DOL, you would need an underlying status, meaning an H-1B status or any other, to keep you here in the country. And yes, we will be sharing our presentation with you guys. Our team will be doing that. We have a list of all people that are enrolled in this webinar, and you will be receiving our presentation, maybe not today, but tomorrow or Monday tops.
Mm-hmm.
Let me see here in the chat. It is very important to share with you guys that we have a visa guide that is made available to you through our website. So if you have any questions on visas in general, not only the H-1B, you can find it there. Let me see what questions we have. Here. Chris, Mr. Gomez is asking, if you have a PhD degree, do you have any advantage to get an H-1B visa?
So you're still subject to the numerical limit of $85,000. There is 85,000 visas. I keep saying dollars, thinking about money. But a PhD would be within the $20,000 for 20,000 visas reserved for US master's degrees or above if it's a US PhD. If it's a regular PhD from abroad, it wouldn't actually even fit within that 20,000 visa category, and it would be just subject to the standard lottery. But in terms of benefit, a PhD definitely looks good. And that might mean that the person is highly qualified at that job. That might also mean that they're due a higher salary, though. So that's another consideration. But it does look good. And a person with a PhD would definitely be considered a professional if the occupation required at least a bachelor's degree or above.
Perfect. Then we have a question from Wellington. He's asking if a technologist graduation can be used too for H-1Bs.
So I'm not 100% sure what technologist is referring to. Does that mean like a technical degree, like not a bachelor's degree?
So Wellington Cato, if you could please email us, I'll be giving you, providing our email address soon. And if you want to clarify what a technologist graduation is, we can gladly answer that question to you.
Yeah. But in general, I'll just touch on, I guess, a little bit of that topic. The job would have to require at least a bachelor's degree. So if it's a job that generally in the industry would only require a vocational degree below a bachelor's degree, then it wouldn't qualify for an H-1B. However, if the person only doesn't have a full bachelor's degree in terms of study, if they only completed a couple of years, even if they only completed a vocational degree, but the job normally requires at least a bachelor's degree and they have significant experience, then it would be a separate topic, but it can be argued that their experience and education in combination can qualify as a bachelor's degree.
Okay, so then we would have to submit that to one of our specialists or partners to review that like their history and everything to see if we could qualify it. Ms. Guerra is asking if a spouse of an H-1B or an H-4 is allowed to work here in the US.
Excuse me, what was that?
If an H-1B spouse can work, is allowed to work.
Not generally, as policy is currently written. The exception is if the H-1B holder has an approved I-140, then at that point, an I-140 refers to like a perm, so the green card stage. At that point, the spouse can possibly obtain employment authorization, but that would be down the line. So it wouldn't be initially.
Okay, thank you. We also have a question posed by Bruno. He's asking if I have an H-1B or if I'm holding an H-1B, can I apply directly to a green card?
Directly in the sense that while you're in H-1B status, a green card process can be initiated immediately. That is a possibility. It's the perm
But it would
process.
have to be through a perm, right? So
yes.
Also, Bruno, please email us and we will gladly schedule a call and go over the EB2 perm process with you. Aline has gracefully shared with you guys our profile. So both Chris's and I, our LinkedIn profiles. And she has posted here the email address that you can use to email us. So it's info@drummondadvisors.com. Let me see if there are more questions. So, well, just to tell you, Chris, here, Wellington has clarified that it's not a bachelor's degree, but then we already went over that, right? We might
Yeah.
have to submit that to an event, to like park evaluations or some partner to see if we could combine both your diploma with your experience.
Yeah. So in general, I guess just keep in mind that there are two separate considerations. The job has to qualify for as an H-1B job, as an H-1B profession, and then the prospective beneficiary also has to qualify for that role. So with this, this technical degree, let's assume that the prospective employer is in HVAC repair, so heating, vacuum, air conditioning, and ventilation. And the prospective beneficiary has a technical degree in that job. That wouldn't qualify as an H-1B job because it wouldn't be considered a professional
Specialty
job.
occupation. Right?
Specialty occupation, yeah. And the person, regardless of their experience, wouldn't qualify for an H-1B as well because the job in the first place isn't an H-1B job. So that's something to keep in mind.
Perfect. Well, Chris, we don't have any more questions. So that means you did a terrific job, an amazing job with your presentation. It was clear to everyone, so no questions, no more questions. Thank you so much. I think it was an amazing opportunity to share information on the H-1B process. It is that time of the year, so please let us know how we can help you with your H-1B case. It will be a pleasure to meet with you, to schedule a call with you. Anything to add, Chris?
Just keep the timeline in mind, and we're already in H-1B season. We have 2 months to go to file these registrations, so 2 months passes quickly.
Right, I agree. All right, so thank you, everyone. Please follow us on Instagram, LinkedIn. We're everywhere. We're on YouTube. We have lots and lots of contents in YouTube. Please keep tuned. We're always doing more and more things here. Thank you so much for joining us. Good night. Bye-bye.
Bye.